All right, if you're getting ready for the Queensland bar exams, listen up. There is one tool in your future toolkit that you absolutely cannot afford to misunderstand, and that is declaratory relief. We're talking about the power to get a court to define your client's rights before a wrong has even been committed. Honestly, it's a total game changer, and getting your head around it can be the difference between a pass and a fail. So let's dive in. It sounds a bit strange, doesn't it? I mean, how can a court solve a problem before it even happens? We tend to think of courts as fixing things after the damage is done. But the real power here, the real strategy, is being proactive. Answering this question is really the key to unlocking the massive strategic value of declarative relief. So where does this incredible power actually come from? Well, in any exam answer you write, your starting point, your absolute ground zero, has to be Section 21 of the Federal Court of Australia Act 1976. This section is the statutory gateway. It's the front door to everything we're about to talk about. If you get this right, you are well on your way. Okay, the power flows directly from the wording right here in Section 21, subsection 1. The court can make binding declarations of right. And, this is the crucial part, it can do that whether or not any consequential relief is or could be claimed. This is then backed up by subsection 2, which says a lawsuit isn't invalid just because a declaration is the only thing you're asking for. That right there is the core of its standalone power. So just how wide is this power? Well, we don't have to guess. The court tells us itself. In the Oscar Wiley case, the power under Section 21 was described as, quote, very wide. Now, that's not just some throwaway comment. It's a principle you can, and you absolutely should, cite with confidence in your exam. It shows the examiner you get that this is a significant, flexible remedy. But hold on. Very wide does not mean unlimited. Before a court will even think about using this power, you have to clear a really critical jurisdictional gate. And this is the constitutional requirement for a matter. Seriously, without a matter, the court has no power to act. Full stop. So what in the world is a matter? Well, as the court put it in Sui and Te, it's about establishing some immediate right, duty, or liability. The key takeaway here is that this prevents the court from just giving out advisory opinions on abstract or purely theoretical what-if questions. There has to be a real, live controversy between the parties that the court needs to resolve. Okay, so let's say you've established the source of the power in Section 21, and you've satisfied the jurisdictional requirement of a matter. Now we get to the absolute heart of the analysis for any exam problem. How does the court decide whether or not to actually grant the declaration? This is all about judicial discretion. Now, when we're talking about judicial discretion in this area, there is one case that is completely non-negotiable for your exam. Ainsworth v. Criminal Justice Commission. This is the seminal High Court authority. Your entire analysis of whether a court will grant a declaration has to be filtered through the principles laid out in Ainsworth. So Ainsworth gives us this balancing test. The court is basically weighing factors in favor of granting relief against those that argue against it. On one side of the scales, does the applicant have a real interest? Will the declaration actually have foreseeable consequences? But on the other side, is the question purely hypothetical? Is this whole thing about circumstances that might never even happen? Nailing this balancing act is exactly where you're going to score those top marks. Now that we've got the core framework down, let's explore some of the, let's say, trickier scenarios. The ones that really test a deeper understanding. These are the kinds of issues that separate a good exam answer from a truly great one. Right, here's a classic. What if both parties want the declaration? They rock up to court together and ask for it by consent. Seems like a slam dunk, right? Wrong. It's a trap. Remember, the court is not a rubber stamp. Parties cannot just give a court jurisdiction it doesn't have. The judge must always be independently satisfied that making the order is an appropriate exercise of judicial power. Okay, what about default judgments? Let's say the other side doesn't even bother to file a defense. Can you get a declaration automatically? Well, the courts are extremely reluctant to do this, and the guiding principle is that a judicial declaration is a serious order. It has to be based on evidence, not simply on a technicality like deemed admissions. So your starting point should always be that the court will be very unwilling to grant a declaration by default. Oh, this is a classic exam trap. Just imagine this. Your client needs an urgent ruling on their rights, like right now. But the final hearing is months away. It seems perfectly logical to ask for a temporary or an interim declaration, just to hold the line, right? So the million-dollar question is, can you do it? The answer is a massive, emphatic no. The High Court in Duro v. Wilkins was crystal clear on this. An interim declaration is, and I quote, a form of order not known to the law. It just doesn't exist. A declaration is, by its very nature, a final determination of rights, not a temporary one. Do not make this mistake in the exam. Okay, we've covered a lot of ground. We've talked about the power, the jurisdiction, the discretion, and those tricky special cases. Now let's pull it all together into a clear, strategic framework that you can take straight into your exam with you. So when you're staring down an exam problem, I want you to structure your answer just like this. Step 1, establish the power. Where does it come from? Section 21. Step 2, establish jurisdiction. Is there a constitutional matter? And step 3, analyze the discretion. Apply the Ainsworth test to the facts. Power, jurisdiction, discretion. Walk through those 3 steps every single time, and you will have a rock-solid answer. All right, for your final revision, I want you to burn this checklist into your brain. The power, Section 21. The jurisdictional gate, the matter requirement. The discretion test, Ainsworth v. Criminal Justice Commission. The hard and fast rule you can't forget, no interim declarations, and the case for that is Dudro. And what's the court's fundamental rule? It must always exercise its own independent discretion. Know these cold. We started with a question, so let's end with one too. You now have the legal framework, but the real art of being a barrister is applying it. So I want you to think about it. In what situation could you use this powerful, proactive tool not just to fix a problem that's already happened, but to stop one from ever happening in the first place? That is the strategic thinking that will set you apart.